no, I don't know. Everybody knows I do not allow people to work as home health care providers when you're on probation for a felony. Everybody knows that. So my question is, have you had employment since April 30th, 2024? Is
She had a
calling
plea deal for just over
2023
200
CR
days. All she had to do
7787,
was
State
show
of Texas
respect.
versus Anna Marie De
Instead,
La
she
Rosa.
told
Can
Judge
I have
Boyd
parties
she
announced
didn't
for the
see a
record for the
problem
state?
with leaving the county without permission, blamed the
Defense?
court
Ray
for
Lopez
blocking
for the
her job,
defense.
and watched
All
her deal
right. And
evaporate.
are you
14
Miss De
months
La
in
Rosa?
state
Yes,
jail.
Did you
That's
review
the
the
cost of
document entitled
excuses.
motion? Is calling 2023 CR 7787, State of Texas versus Anna Marie De La Rosa. Can I have parties announced for the record for the state?
State.
Defense?
Ray Lopez for the defense.
All right. And are you Miss De La Rosa?
Yes, ma'am.
Did you review the document entitled motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Anna Marie De La Rosa who was placed on deferred adjudication in 2023 CR 7787 for the offense of burglary of a building with intent to commit theft on April 30th, 2024 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, the state wishes to proceed on violation of condition number 6 on or about the 10th day of July 2024. The defendant, Anna Marie De La Rosa, departed Baird County without the written permission of the court and or supervision officer in violation of condition number 6.
How do you plead to that? True or not true?
True.
We waive and abandon all of this, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 6, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 6?
Yes.
Court will find violation of condition number 6 true. Is there a proposed agreement?
There is, Your Honor, it is for the state's motion, enter an adjudication of guilt against the defendant, revoke her community supervision, and sentence her to 232 days in the Baird County Jail under Texas Penal Code 1244A.
All right, so why would I follow this agreement? Because I'm assuming that's a judgment satisfied.
It is, Your
All
Honor.
right, why would I do that?
Your Honor, she's contesting the charges that she picked up in Medina County. She does admit, though, that she left the county without permission and remorseful for that. And is looking to put this matter behind her.
Oh, I'm not, just so everybody understands, I'm not considering anything else on the motion. I'm just considering violation of condition number 6. Has she done anything on probation? Has she completed anything? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Anna Marie De La Rosa.
All right, what have you done on probation?
I reported to probation. I've also been looking for work, like as said on my probation. I had work in line, but considering that I left,
Why did you leave the county?
I had to go and pick up my sister-in-law from where she was at because she got stranded. So
Probation. And tell them,
well,
I need to go pick up my
I
sister.
mean, I didn't think it was an issue and a problem because I didn't think I was violating probation at that time. And she just needed a ride, so I went to go and get her. So I mean, I didn't see where there was a problem or an issue at that moment in time because it was just going and picking her up. And that was I didn't see that there was a problem.
Did you start on your parenting classes?
No, I have there was a parenting class that was in line for there.
No, my question is, did you start your parenting classes?
No, ma'am, I didn't.
All right.
But the reentry program does have those parenting classes, and so I just had to wait to get into that program.
Were you in felony drug court?
No, they said they denied me because I don't have no drug issues since 2017. My case wasn't related to drug issues.
And
I didn't
you're
come
not
in on no drug
employed?
charges or anything, so they drug court denied me because I have no drug.
Have you been
charges.
employed since April 30th, 2024?
Have I been employed?
Yes, since you've been on probation, have you ever had employment?
Well, my probation officer was supposed to check in with you because, I have a history of working, through a providing agency. But because you took that away from the only,
Oh, no, I don't know. Everybody knows I do not allow people to work as home health care providers when you're on probation for a felony. Everybody knows that. So my question is, have you had employment since April 30th, 2024?
no, so I was looking for.
All right, so that's a no. Did you report to probation
I
since
did tell-
April
I
30th of
did tell,
2024?
yes, yes, ma'am, I did. And I was, also calling the hotline like it was told to do. I was doing my conditions as followed. Yes, I was.
Any other questions?
And I also called my probation officer to let her know where I was at. I tried contacting her several times and stuff. So, I mean, I did everything that I was supposed to do. I do have job lines followed as well when I get out of here too.
But you haven't had an employment since April 30th, 2024. Any questions?
Ms. De La Rosa, did you complete your TAP evaluation? as
Yes.
ordered by the
Yes,
court?
ma'am, everything was done.
When do you recall doing that?
When I was incarcerated in Bear County. It was a top evaluation and then it was followed through drug court, which they denied me because like I said, they said because I don't have no drug history, there was no reason for me for them allowing me to take that course.
And then, so you were released from custody in June of 2024, does that sound right?
Yes, ma'am.
Okay, and then, you were ordered to submit to drug testing in July of 2024, do you recall that?
For the phone.
Yes.
Yes, and I was calling every day like I was told up until the time that I got placed into Medina County. And then I was there for 4.5 months.
So are you aware that your probation officer stated that you failed to submit to drug testing on July 12th, 19th, and 26th of 2024?
Because I was already incarcerated.
You were already incarcerated in July. And then are you aware that your probation officer is alleging that you struggled with calling the UA hotline as you were instructed to do?
If I wasn't incarcerated, how was I able to call the hotline?
So when were you incarcerated?
July 12th, 2024.
But before that, are you aware of any that your probation officer is alleging that you were having trouble, calling in on the UA hotline?
Because I was already incarcerated in July.
Or your incarceration?
There was no, I was calling every day. There shouldn't have been a reason why.
All right, any questions?
Yeah.
Probation,
That's good.
what is probation's recommendation?
Judge, the court summary indicates they want revocation.
All right. Any objection to the court reviewing the court summary?
No.
Thank you. All right, thank you. The court is going to grant the motion, find you guilty. The court will revoke. The court will sentence you to 14 months in the state jail for credit for any time served. There's to be no contact with Veronica Garza or 1803 Macaulay, MCCAULEY, San Antonio, Texas, 78224. And no contact with Jose Gutierrez. I'm sorry, with Grace Rocha and Jose Gutierrez. And Raquel Puente. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck. 2022 CR 4501, State of Texas versus Samantha Lee Lopez. Can I have parties announced for the record? For the state,
Ashley Jones.
defense,
Amir Memorial.
and are you Miss Lopez?
Yes, ma'am.
Counsel, have you received all of the discovery?
I have, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Lopez, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Ms. Lopez, did you review the admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault, family, choking, strangulation? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at $1,500 fine. State recommends deferred adjudication. This is to run concurrent with County Court Cause number 633165, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be 160 hours of community service restitution, no contact with Stacy, Stacey Reyes. There's to be the BIP, P course, TAP evaluation, and no possession of firearms. Legally, you're not allowed to possess any firearms. Do you understand?
Yes, ma'am.
Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the plea?
Yes, Your Honor, state would offer to admit State's Exhibit 1 and all attachments.
No objection, Your Honor.
All right, and state, have you had contact with the complainant?
Yes, Your Honor.
All right, you may be excused.
Thank you, Judge.
Ms. Lopez, did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. Reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Is there anything you wish to say on behalf of your client?
We respectfully ask the court to follow the agreement, Judge.
All right, why are you violent? What's going on with you?
At the time, I was not in a very good mental state. I was in an abusive relationship. Things just got out of hand.
Abusive relationship with who?
With the Stacy Reyes, ma'am.
All right, she said you tried to run her over in the police report, which you stipulated to this. She says that you ran her over with a car before. And according to this, she went out, she got promoted at work, she didn't come home, she decided to celebrate with whomever she decided to celebrate with, and then she's saying you choked her and beat her up. So again, what's wrong with you?
Ma'am, at the time, we have been together for 15 years before that, off and on relationship. We had a lot of issues.
So why don't you just leave?
I have-
After, according to this, after you ran her over with the vehicle, why didn't you leave? I'm
was
thinking
not
if
in a
you're in a
good-
relationship with somebody and it gets to the point where you're running them over with a vehicle, maybe that relationship should be over.
Yes, ma'am, I agree.
So why didn't you just leave?
I just wasn't in the strong enough headspace to leave. I felt like she was all that I had, and I wasn't in contact with family at all. So I stayed and things just got worse.
All right, but according to this, you're the one who's beating her up, not the other way around.
I'm the only one that got the cops called on me.
Well, when she said you ran her over with the vehicle, she said she was dishonest with the police and said, I don't remember what happened.
But I'm just saying, I never called the police on her. I could have several times, but I chose not to. So there is no record of that, unfortunately.
So for this, when this happened, they don't mention that you have any scratches on you. It's just she's the one who got beat up and choked out. So,
Yes, ma'am. And
so
that night-
obviously you can choke her out because you did.
Yes, ma'am. That night, she did also put her hands on me, but I'm stronger than she is. I wasn't harmed as badly as I harmed her.
No, it says here, there was an argument. She says you punched her several times in the face and choked her. And you choked her. They observed petechiae in her left eye from you choking her out. And that she pretended like she was just going to go outside to get some air, and you gave her her phone because you didn't think it could work, and her phone was broken.
Yes, ma'am.
So it
I'm-
appears you have an anger issue. So
Yes,
where is
ma'am.
your anger issue coming from, and why do you think that might makes right in relationship? Because that's what's happening here.
The anger was just stemming from all the past history of that relationship. I have worked on myself a lot since then. I'm not denying anything from that night. I know that I did wrong. And I have regretted it since then. Since that night, I never put my hands on her after that because I felt so badly about what I had done.
Are you all still together?
No, ma'am.
All right, because that relationship is over. You understand that?
Yes, ma'am.
Do y'all have any children together?
No, ma'am.
Do you have any property in your name
Together?
with her? Yes.
No, ma'am.
All right, so that relationship is over.
Yes.
Do you have any children?
No.
Are you employed?
Yes, ma'am.
What do you do?
I work at a nonprofit pet rescue.
Mhm.
I'm a supervisor.
All right. So this is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine that will be probated. This will run concurrent with 6 33165. That's a misdemeanor case. There's to be an affirmative finding of family violence. There's to be no contact with Stacy Reyes. And if you're doing sober support meetings with that DWI, I know sometimes they tell you as part of your rehabilitation, you have to apologize to people that you've done wrong. You're not allowed to apologize to her. You understand?
Yes, ma'am.
No contact. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Make sure they test for alcohol. Field visits, 1 time per month for 3 months. The BIPP course. TAP evaluation out of custody. And probation, since she's on probation in the misdemeanor case for a DWI, they may have already done a TAP. If they have not?
No, Your Honor, that plea hasn't been.
Oh, it hasn't been done?
No, Your
Okay.
Honor.
So TAP evaluation out of custody. I'm going to want 90 sober meetings in 90 days. There's a 160 hours of community service restitution. Probation, I know what BIP does, but is there any type, she's saying that she was abused as well. Is there any type of program for her? All right, we'll do trauma assessment. And if trauma assessment requires a class, then I'll waive the 160 hours of community service restitution. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Relationships are work. People think it's all bed of roses. It is not. Anybody who's been married for a long time, they will tell you it's work. You know, relationships and marriages are not the wedding. It's what comes after. So this is what you need to do. You need to go to one of these stores, get you an orchid. They are beautiful. They have beautiful flowers on it. Make sure you get one that has all the flowers on it and bring it home. And when those flowers fall off, if you're able to get that orchid to rebloom, then maybe you're ready for a relationship. And let me just tell you why I say that. Orchids takes patience. They take time. You get those instructions from the store, and then people tell you, you're not supposed to put ice in orchids, right? But they give you instructions to do that. Orchids don't like to be moved around. Sometimes they're very finicky. They like the sunlight, then they don't like the sunlight. And if you are patient enough to get that orchid to rebloom, then maybe you'll be ready for a relationship. Because guess what? A relationship requires patience. It requires acceptance. And anytime you're thinking about throwing that orchid away, that's like with relationships. Anytime you think about putting your hands on somebody, maybe it's time for you to leave. You understand?
Yes, ma'am.
All right. In this court, communication is key. If there's an issue, you need to let your probation officer know. If you feel as though they're not addressing your issue, you can come to court. And if the complainant comes back to you because maybe she wants to rekindle things, you need to call the police, because otherwise you're going to be violation of your probation if you visit her and if you allow her to live with you. You understand?
Yes, ma'am.
All right, good luck to you. 2025 CR 010958, State versus Kenora Adams. Could I have the parties announced for the record?
Espinoza for the state.
And Kelly Piddle for Nora Adams.
And are you Miss Adams?
Yes.
All right, you previously been sworn in, and you were actually here on October 14th, 2025. There was a request to withdraw your plea. And you wanted a jury trial?
Yeah.
All right. And are you asking now to enter into a plea bargain agreement with the state?
Yes.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Probation, this is an application. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with the offense of robbery. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Adams, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine.
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
All right, off the record for a moment. It says it's running concurrent with a PF case. Where is that?
It's in County Court 2.
Okay, and that's the correct cause number?
Mhm.
All right. All right. And while the state is reviewing that, did you review the plea bargain page?
Yes, ma'am.
Okay, according to the plea, punishment is to be assessed at a $1,000 fine. There's no application for community supervision. The state recommends deferred adjudication. This will run concurrent with 2025 PF 40428. Court is being informed by defense counsel. That's the county court cause number.
Yes, Judge, and that is the pre-file, but the filed case number will be 2025 CC 014365.
365.
Yes.
Any objections to the court adding that to the paperwork?
No.
All right, so, and it's to run concurrent with 2025 CC 014365, which is also 2025 PF 40428. And the state will take in consideration 2025 CR 010957. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes.
State is at the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 150 hours of community service restitution, no contact with the complainant or 7-Eleven convenience stores, MIC evaluation, referral to Center for Healthcare Services, MRT, and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, state offer states exhibit 1 and all attachments.
No objection.
Did you contact the complainant?
Yes, Judge.
All right, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, but most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Assessing felony murder.
All right, Ms. Adams, they're requesting a referral to Center for Healthcare Services. Have you ever been diagnosed in the past?
I've been diagnosed with depression through the military,
Okay.
and anxiety, and I just recently had a baby, so postpartum.
Okay. All right. So what branch did you serve in the military? Okay. I'm always wondering with the Navy, if you're on a submarine, I don't know if I'd be able to do that. So how long were you in the Navy?
7 years.
Okay. And do you have family support here?
No.
Okay. Where is your family? Which state?
Illinois.
Do you want to transfer back to Illinois? Okay. No, if you want to transfer back to Illinois, we can do that. So are you 100% sure that's what you want to do?
It's up in the air. I have a house in Texas that I'm still trying to do.
Okay. All right. So this is what we're going to do. Ms. Abrams, can you see if Veterans Treatment Court is down here? All right. So what we're going to do is we're going to get Veterans Treatment Court. Not necessarily going to place you in Veterans Treatment Court if you don't want it. But if for some reason you're not able to be accepted into that program, they'll be able to give you different type of programs for outreach.
Is this an offense that qualifies? That's why I didn't.
Oh,
It did. I wasn't sure that. Okay.
they do a lot on case by case basis.
Okay.
All right. So do you have any help at home with the baby or anything?
So I'm dealing with a CPS case that is permanent, to kind of mitigate some of the symptoms that I have, like with my anxiety and depression. I smoke marijuana. And so I kind of got into trouble with that because I ended up having my daughter at home 7 months ago, and they made me go to the hospital. One of the questions that they asked was because I smoke marijuana. I asked first to release. I had been working on a medical marijuana card prior to me being arrested, but I did get my medical marijuana card, so that's why I wanted to make sure, like during the probation, would that be an issue? Because I do have my medical marijuana card.
No, just make sure that you give that to your probation officer, so that won't be an issue, and your attorney can help you get that to them. All right. All right. So does she have any type of priors or no?
I don't believe she has any criminal history, Judge.
No criminal history?
No.
All right. So it seems like on this day, everything just converged.
It was a bad day, Judge. She found out she had a warrant for an unrelated case due to the leaving court early, is my understanding. So she was having difficulty at that time.
Which court was that? They said she was
7 or 13. One of the two family violence courts. And she didn't have her wallet. She took a can of Coke. Her wallet was outside. So unfortunately, she took the can of Coke out, and then she had the money to pay for it. And then that's what happened.
Well, I was just having a bad day. My body suit had broken. Officer Wilson, the ninth officer, and he came and said, "Ms. Adams, you can't walk around like that." He gave me the paperwork to go home. So after I went home, I didn't go home. I had to go sit at a McDonald's while I was with my spouse waiting because we only had one vehicle. After that, I walked over to the 7-Eleven and grabbed me a Coke. I realized I left my wallet. But before all of that happened, they called me and said I had a warrant out for my arrest because I only came in one court.
Okay.
And so I was stressed out that day. I'm like, man, I've been dealing with these bail bondsmen. I've been communicating with you guys. I got arrested when it was the other way around, but Grabbed the coke, me and him get into a physical altercation. He said, I was trying to steal the coke. I explained to him, my wallet is at the McDonald's next door. Can I please grab it? He grabbed the coke. I went back to McDonald's, grabbed my wallet, came back, tried to pay for the coke. He told me to get the F out the door. And I said, I started knocking over a couple pieces of candy, and that's when he called the cops and they came and arrested me. So originally when I took the coke out of the store, he didn't call the police. He just told me to leave. But just so I could show good faith that I wasn't trying to steal the coke, I was just having a messed up day. I came back in there so I can pay for it, and that's when I had called a retaliation.
All right. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's $1,000 fine that will be probated. Let's do a referral to BTC. Again, it's for them to talk to you. If you decide that's not a program that will be helpful to you, it'll be completely up to your decision. If they want to accept you, just listen and you can talk to them with your attorney and see if that will be a good fit for you. But I think if you're accepted, it will be a good program because one, they'll be able to help you. Perhaps if you want to also transfer to and help you with any other issues that are happening. So referral to VTC, CPS compliance, field visits 1 time per month until further notice. This is to run concurrent with 2025 PF 40428, which is also 2025 CC 014365. Take into consideration 2025 CR 010957, 150 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, the community service hours will be deemed satisfied. If they're requiring you to do parenting classes on the CPS side, that will count for the parenting classes that I'm requesting. MIC evaluation out of custody. Are you receiving any help through Center for Healthcare Services or anyone?
In regards to services, what do you mean?
Mental health.
Any mental health services?
The VA.
All right. So there's to be continued mental health treatment through the VA. And I'm sorry, with the community service hours, once parenting classes are completed, 50 hours will be deemed satisfied. The remaining 100 hours will be deemed satisfied once anger management is completed. And there's to be no contact with 7-Eleven convenience stores. So you're going to have to go to somewhere other than 7-Eleven. Probation, is there anything else? I'm just asking him if there's anything else. Proof of employment within 60 days. No employment as a home health care provider or with minors. Is there anything else?
And you did say regular court.
Of course I did not, but I appreciate you covering for me. There's to be regular reporting by Zoom or in person and regular random UAs, or she can do a patch. Your attorney will explain to you what the patch is. And she does have, she says, a marijuana card. So she'll be giving that to you. Is there anything else? Is there anything else you need from the court in order to be successful?
Can't think of anything at this time.
All
But
right.
I will say this, Judge.
Yes.
While I have been on house arrest, some of the girls, while I was incarcerated, told me that you had a YouTube channel, so I got an opportunity to watch a couple of your videos.
Okay. So, and I hope that means that this wasn't, I always tell people, court, yes, can be a scary place, but hopefully people will become educated about what happens in court, how to dress appropriately, how to respond appropriately. So you're currently on GPS?
Yes.
And is that through this court?
Yes, sir.
All right, State, do you have any objection to removal of GPS?
No, good.
All right, and remove GPS. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
That's the thing.
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So here's the thing. In this court, to be successful on probation, communication is key. If there's an issue, call your probation, let them know about it. If you feel they're not addressing it, you can always come back here and address it with me, all right? All right, good luck. And somebody from Veterans Treatment Court will come down and speak with her. All right, so this is being recalled, and the reason why it was being recalled because it had to do with the amount of restitution, correct?
That's correct, Judge, and you felt like the paperwork submitted did not substantiate other than her conviction, the exact amount or.
So do we have an exact amount now?
Well, no, Judge, we've got no more discovery. I thought maybe they would come forward with some itemizations. And it's.
All right, so part of y'all plea bargain agreement was the agreement of restitution of 14,000. So that's not a part of the plea bargain agreement?
It is, Judge.
A part of the plea bargaining agreement, Your Honor.
So then why are we having a restitution of $14,000 if you all agree that $14,000 is the amount?
Because you ordered it, Your Honor.
Okay, yes, so what do we have?
Nothing further that was previously tendered for the court. I've been checking discovery on that, kind of thinking. So it may be that your concerns have not changed.
All right, because the police report says she took between $13,000 and $15,000. So are you going to agree that you owe $14,000?
I don't know how much it was.
No. My question is, are you going to agree that you owe $14,000?
Agree.
All right, we're going to go on the record. Court is calling 2023 CR 2580 State versus Desiree Nicole Sariana. Serini, how do you pronounce it? Sariana. Could I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense?
Tom Beck for defendants.
And are you Desiree Sariana?
Yes, ma'am.
All right, so we're back here for restitution because according to the police report, it says that they think she took somewhere between $13,000 and $15,000. So are you in agreement that it was $14,000 defense?
Well, she signed the plea bargain agreement.
All right, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
No.
All right, you can lower your hand, state your name for the record.
Desiree Nicole Soriano.
All right, according to the plea bargain agreement, you agree that you took $14,000 from the complainants, is that correct?
Yes, ma'am.
All right, so in the police report, this is Walmart, and Walmart says that the defendant admitted to taking somewhere between $13,000 and $15,000 of not placing money in the recycler. So how are you planning on paying this back? Where do you work?
In Amazon.
All right, are you making enough money to pay back $14,000?
Yes, ma'am. The payment.
One person at a time, please.
I'm sorry, what?
In payments. In payments.
All right, so here's the thing. You were working at Walmart and according to the police report, you took $14,000 because you needed for bills and housing and insurance. How is that any different working at Amazon? Is Amazon paying you more?
Right now I'm getting paid $19.30 or.
Sorry, what?
Right now they're paying me $19.30 and I'm living with my partner and my partner is the one that's paying the bills.
And so if,
So I can pay the money back for.
all right, so if your partner leaves you, will you be able to pay this $14,000?
Yes, ma'am.
All right, people say that because they want probation and then we end up right back here. I'm not going to do what other judges would do. What other judges would do would say, they're not accepting this agreement till you pay the $14,000, and they usually would give you a month to come in with $14,000. So do you have a specific amount, sort of as a down payment towards paying off the $14,000 that you can pay?
No, ma'am. What do you mean, like a down payment, something to start it off? today?
Yes, like $2,000. Do you have $2,000?
No,
How much money do you have to pay towards this $14,000 restitution today?
right now, nothing.
Why do you have nothing to pay if your partner is paying all the bills? What are you doing with your money?
She's the one that told me that she would pay the bills while I do the monthly payments. The money that I have saved, I've been using to come over here because I live in Amarillo now, so I'm having to drive over here for court.
Right, no gum chewing.
So
All right, so how much does it cost to drive to court from Amarillo?
like $100.
All right, so you've been here to court 2 times. This is your 3rd time.
$100 to come and then $100 to go back.
All right. So that's $600. So what do you have to pay towards this $14,000?
Right now, nothing. I can see what I can come up, like ask family members to help me out for a down payment.
Ms. Abrams, will y'all be able to put her on a schedule where she can pay off $14,000? Are you gonna be able to pay $500 a month?
Yes, ma'am.
All right, Miss Abrams, in order for her to pay off this $14,000, she needs to pay $500 a month towards restitution. You understand?
Yes, ma'am.
And we're gonna start her first payment. We'll start it November 1st. You understand?
Yes, ma'am.
All right. State, you may be excused.
Thank you, Your Honor.
Court is gonna sentence you to 4 years deferred adjudication. There's to be no contact with Walmart. There's to be $500 per month for restitution. There's a $500 fine that would be probated. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person, regular random UAs. Do a transfer to Amarillo. What county is that?
I believe it's Potter.
All right. It'll be transferred to Amarillo. And if they're able to do field visits in Amarillo, it's field visits 1 time per month for 3 months. There's to be 200 hours of community service restitution. She's going to do a theft course. Once you complete the theft course, 100 hours will be deducted. Do you have any children?
No, ma'am.
All right. And then she'll have to complete the remaining 100 hours of community service restitution. Probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, when you come up short on your bills, stealing is not the answer, because then guess what ends up happening? You're still gonna pay that money back. Now you have something on your record that's called a crime of moral turpitude, which is very bad. So if you try to get a job that requires you to have a license, this is gonna pop up on your record and non-disclosures will not help you. Do you understand?
Yes, ma'am.
In this court, I require that you report. In order to be successful on probation here, communication is key. So if there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
And you need to handle your bills and know that you need to pay $500 a month towards restitution. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank
2020 CR 2289, State of Texas versus Michelle Andrea Garces. Could I have parties announced for the record for the state,
Jason Garrett, hand, Your Honor.
for the defense?
Luis Martinez.
And are you Ms. Garces?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? You need to speak up.
Yes.
Did you understand it?
Yes, ma'am.
Are you the same Michelle Andrea Garces who was placed on deferred adjudication in 2020 CR 2289 for the offense of possession of a controlled substance penalty group 1, 4 grams to 200 grams on January 27, 2021 for a period of 2 years and extended for a total of 1 year? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 5 in Bear County, Texas. The defendant, Michelle Andrea Garzas, is in and there failed to report to the supervision officer as directed for the months of April 2023, May 2023, June 2023, and July 2023, a violation of condition number 5.
How do you plead to that? True or not true?
We'll waive the remaining violated conditions, Your Honor.
Any objections?
No objections, that judge.
All right, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
All right, court will find violation of condition number 5 true. Is there a proposed agreement?
No, there's not, Your Honor.
All right, state, what are you requesting?
State is requesting one of two options. One would be SAFP with an extension, Your Honor, or revocation.
All right, and defense, what are you requesting?
Judge, we're requesting that she be extended, but that she be placed on a mental health caseload and evaluated in that respect, because we believe that's where her needs are.
All right, so why wasn't she reporting?
Judge, so she was going through a mental health crisis while she was participating through the felony drug court. She was taking a Laurel Ridge, that caused an issue, caused her to be exited from the program she was with felony drug court. After that, she did not contact me, did not report after that. She knew that she had a warrant out for an MTR. But she's been participating with the Center for Healthcare Services, getting her meds, getting her counseling through them. She represents to me that she's clean today, so I suggest, or I would propose that we have her drug tested. Because I don't believe at this point that her needs are primarily simply substance abuse. She's been diagnosed as bipolar, she's got PTSD, she's been sexually abused in her past. She had a difficult upbringing, given that she is a lesbian and that was not accepted in her household until very recently. And so all of those factors together have put Ms. Garces in a position where she certainly does have some very substantial mental health needs. Judge, I've got some documents from the Center for Healthcare Services the state's reviewed and has no objection to that indicate that she's been diagnosed consistent with those diagnoses. Indicates that she is going to the Center for Healthcare Services. Indicates that she's been prescribed medication and is staying on those meds.
All right, so it still doesn't explain to me why she disappeared for all of those months.
Well, she got exited and she didn't make good decisions. Had she contacted me, Judge, obviously, we would have come back to the court and communicated with the court. Unfortunately, Michelle, like with most people in this court, didn't deal with the problem until she got arrested.
All right, and see, the problem the court has is this is not her first motion to revoke. So, probation?
Judge, probation. They stand either NC or revocation.
Those are your choices.
And Judge, I don't think that adequately addresses the mental health needs that she's got. And certainly we haven't addressed that to this point.
Mhm.
And without those, I don't think that she was ever gonna be successful. And I know that that was not communicated to the court, but I'm doing that now. Once again, I propose that we have her drug tested. If she's clean, then we know that she's got some control over her drug issues.
So here's your problem. You were in felony drug court, and I know that felony drug court would address mental health issues, but if you're not showing up, then they can't address mental health issues. Right. And you were previously on the mental health caseload. So your options are, you can go to SAFP, or if you want to be revoked and just do your time, I can revoke you and I can sentence you, I'll sentence you to 3 years in the prison. So which do you prefer? So those are your options, SAFP or either revoke for 3 years.
Could we step aside, Judge?
Yeah. Yes, you can step aside in the box.
Yep, yes.
Okay. And what I'll do is, counsel, I can bring you all back at 1:30. Okay. All right. Yeah,
So she's gonna be able to book?
yes.
A mother, drunk and furious, forces her way into a relative's apartment looking for her son. She catches a felony burglary charge. Today she begs for deferred adjudication, but Judge Boyd reads the police report aloud, and the details change everything.
2025 CR 0035550 State versus Leslie Martinez. Can I have parties announced?
Rick Maynard for the state of Texas.
Jim Alters door for Leslie Martinez.
Are you Ms. Martinez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I did.
Court will find that the state is in compliance with discovery. Ms. Martinez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes,
Did you understand it?
yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we will be waiving paragraph A and proceed on paragraph B.
All right, any objection?
No objection.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a habitation? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
All right, off the record for a moment. Oh, they were saying it was a false alarm. We're back on the record.
My wife is outside. She just let me know.
Okay. All right, we're back on the record. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
All right, so you understand what your rights are.
Yes, ma'am.
You're giving up those rights by entering into this plea bargain agreement. Did you understand that?
Yes.
And are you intending to do that?
Yes.
All right, did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and the court could sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Deputy Laura, can you have them move to the other end? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, to both questions.
Ms. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, ma'am.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be 100 hours of community service, restitution, anger management, TAP evaluation, follow our recommendations, the MRT and parenting classes. But you understand those are recommendations from the state and the court does not have to follow those recommendations.
Yes.
Then to paragraph B in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence State's Exhibit 1 with all attachments.
No objection.
All right, and state, have you had a chance to speak with the complainant?
We have, Your Honor, the complainant would like to come in and give a victim impact statement. Unfortunately, she was unavailable to come in today. We are asking that sentencing be delayed until Thursday so she can come in and do so.
All right. Thank you.
Yes, Your Honor. Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find that if there is sufficient evidence to find you guilty, the court will defer finding of guilt as you've applied for deferred adjudication. So, counsel, I can sentence her today and order her to be back here on court on Thursday, and they will give a victim impact.
That would be fine, Your Honor. May I ask that the court may consider for the fact that I'm court appointed with regard to the fine, maybe probating a portion of the fine.
Yes. All right. So why did you go over to this house?
So I was looking for my son. His dad had taken him, so I went to look for him at his aunt's house because I thought they were there.
So why do you need to look for him? Because he has your son.
Because it was we had a fight, so he didn't leave in good terms. So I was worried about my son.
All right. So this is what people need to understand, and I don't think people understand this. Even though you're a mother of the child, that's the father of the child. And when people have a child and the father takes the child, sometimes mothers feel as though, well, I'm 100% should have the child, and he should only have the child when I say so. Unless you have civil documents that say that, that's not the case. So you're entitled to have the child, he's entitled to have the child. Hopefully, people will be responsible adults and they won't be running around, causing problems or taking a child out of frustration or anger. You have to remember, the father of your child is the person that you chose. You thought this would be a great person to have a child with, and so that's the father of your child. Now, it says in here that she told you that her brother wasn't there and the child wasn't there. So why are you still trying to force your way into the apartment?
I was not trying to force myself into the apartment.
Well, that's why you're here. It says, victim stated to me that on July 17, 2024, around 050 hours, suspect made the location. And that's military time, so not a good hour to begin with. Victim stated that she was awoken by hard banging on her front door. Victim stated she opened the front door thinking it would be her mother. Victim stated when she opened the door, she noticed the suspect, that's you, who appeared to be intoxicated, who told victim she was looking for victim's brother and her child. Victim stated she advised suspect they were not at the location and for the suspect to leave. Victim stated she attempted to close the front door. Victim stated suspect began to force her way into the residence and made entry via her foot and hand. Victim stated suspect was approximately 2 steps in the apartment. and any entry of any part of the body, be it a window or whatever, that's burglary of habitation. Victim stated there was a verbal altercation between the door while holding back suspect from making further entry. Victim stated suspect caused bodily injury when she elbowed victim and caused the door handle to hit victim in the left buttocks. Victim stated there was shoving and pushing with the door between the victim and suspect. While speaking to the victim, she was able to show me bruising on her left forearm and a photograph of the bruise on her left buttocks. Victim stated witness woke up and assisted victim closing the door. So maybe you don't remember, they say you were intoxicated. So here's the thing, when people don't want you at their home, regardless of what it is, you don't force yourself in. If you think your son is there, you think your son is in danger, which it doesn't appear to be because you were intoxicated, you need to call the police.
Yes, ma'am.
So, do you have custody of your son now?
Yes.
And the father of your son, does he see your son?
Yes.
No problems? Now you're here with a felony hanging over your head.
Yes, ma'am.
So is this the only child you have?
Yes.
Are you employed?
Yes.
What do you do?
I work at a call center.
Doing what?
We call to make appointments for hearing aids with Miracle Ear.
Okay. Any drug use?
No.
Any alcohol use?
No.
You're not allowed to drink any alcohol while you're on probation. Do you understand?
Yes, ma'am.
All right. There's a $1,500 fine that will be probated. There should be no contact with the complainant. Regular reporting by Zoom or in person. Regular random UAs. 5 years deferred adjudication. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. TAP evaluation out of custody, follow recommendations. And anger management classes. Probation is and field visits 1 time per month for 3 months. Probation, is there anything else? Sorry?
Employment.
Oh, thank you so much. Proof of employment within 30 days, no employment as a home health care provider or with minors. Is there anything else, probation?
No, sir.
All right, anything else you need from the court?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So State, here's the thing. I know the sister, I'm assuming she's the sister of her boyfriend.
Sister-in-law.
All right, so you may want to talk to her. I don't know if the brother wants her to do a victim impact statement with her, but if they are all trying to be a family, may not be the best. But if she does, this is going to come back. You're going to be back in court on Thursday to hear her victim impact. Do you understand?
Yes, ma'am.
All right. Norma, if you'll give her a reset for Thursday, if there's anything else you need?
No, ma'am.
All right. On probation, to be successful in this court, communication is key. If there's an issue, let me know. If you feel that you've spoken with probation and probation is not addressing it, come back to court, okay?
Okay.
All right, good luck to you.
Leslie Martinez received 5 years of deferred adjudication with a $1,500 probated fine, 100 hours of community service, waived after parenting classes, anger management, a TAP evaluation,